welcome. You're watching the NewsHour Agenda. I am Padmaja Joshi. It's like adding insult to injury. 24 hours ago, a young woman who saw her rapist walk free released a statement. A numb Bilkis Bano asked, how can justice end for any woman like this? And then 24 hours later, one of the members of the panel that granted remission to the convicts in the case spelled out the reason that these men are free. And the reasoning is more sickening than the release itself. BJP's Godhra MLA, C.K. Raulji, who is one of the 6 members of the remission panel, had this to say when speaking to the Mojo story. He said that their conduct in jail was good. They are Brahmins. Their sanskar is very good. They have no past criminal record, and perhaps in a communal clash, there could be an attempt to jail someone under false cases. A justification that has shocked and shamed.
तो उस रेमिशन पॉलिसी की रिव्यू कमेटी में कौन था? एक का नाम था जनाब मुलचंदानी साहब, जो गोधरा के राइट्स में वो एक प्रोसिक्यूशन के विटनेस थे, और दूसरे उसमें बीजेपी भाजपा के 2 एमएलए थे. तो आप इनसे इंसाफ की कैसे उम्मीद रखते हैं रिव्यू कमेटी की?
We shouldn't have any well wishes like Mr. Modi for women, because if this is what he does when he wishes well for ladies, can you imagine what will happen if he wishes bad? Remove this BJP 2 MLAs from their party, and Mr. Modi should dismiss them, but he will not do it. He will never do it, because for them this was an election-winning strategy.
But do you really think this assessment of good sanskar, good behavior, hold any water? Do you think that the deeds of these men, who remember are not just accused, they are convicted of rape and murder, that they speak of sanskar? Does their behavior in jail in any way wipe out their original crime and qualify them for this kind of remission? And finally, what possibly does dragging these men's caste into the argument achieve? But the most important question is and will remain, if Bilkis Bano's rapists stay free, doesn't it belie the very argument of zero tolerance for rapists? Will the Gujarat government right this wrong and roll back the remission for 11 convicts?
You're watching the News Hour at 10, debate number 1 on Times Now, Super Prime Time.
All right, joining us on the debate is Sri Raj Nair, National Spokesperson of the VHP, Rishi Malhotra, Advocate in the Supreme Court, Zeenat Shaukat Ali, Islamic Scholar, Arjun Sharan, Advocate. But I first want to go across to Shobha Gupta, the lawyer for Bilkis Bano. Ms. Gupta, I want to start by asking you, the argument that is being given today is that this is something that is not a special privilege. It's a right of every convict that you seek remission, you get it, if the panel thinks fit. What do you make of this argument?
It's a perfectly fine argument. I don't see anything wrong in this argument. Remission is part and remission policies, and the right to seek for remission is part and parcel of criminal justice system. And that's why we have that. Every single convict has a right to seek for it. The competent authorities have to deal with it. But my only question is, are they bound to grant it irrespective of the serious concerns or the considerations? Are the factors looked into? Is it a mindful decision? Is there application of mind on the factors like the grossness of the crime, the most gruesome crime, 14 murders, 5 gang rapes, a pregnant woman gang raped, her child murdered, relatives, mothers, sisters. Was this a case where this kind of clemency had to be shown? And within 14 years, like 14, 15 years just completed, nobody is coming in the way of the argument that no, whether the accused have a right to seek for, convict has a right to seek for clemency or not, or whether they could have asked for remission, could have been considered. Yes, this could have been considered. But does that Does that create a mandate for the authorities that once an application has to be moved, they have to grant it? I still don't have the order of the committee. So I do not know what are the considerations.
One of the considerations that when we spoke was that there was old age and ill health, which is considered for most other convicts as well. And life imprisonment by its definition is 14 years for some. It's very arbitrary, as has been said earlier. So since they had served more than 15 years, this consideration was shown.
Certainly, ill health could not be the consideration for remission. For ill health, you have hospitals, jail hospitals, and you have facilities. So I'm sure, and even old age cannot be. And even for remission policies, both of them would not be there.
So now, one of the panel members, as you would have seen by now, spoke to the Mojo story, C.K. Raulji, and he said that we examined their behavior in jail, we spoke to the jailer, and that they have shown good sanskar. No past conviction has been there. There has been no past criminal record. Do you think good sanskar is ground for remission?
I'm sure they must have looked into the policy and they must be reading this over there. If the committee has applied their mind to the grounds for remission, the factors must to be considered. See, no remission policy is above the judgments of Supreme Court, which says must look into these factors. Thus, those factors have to be seen into. This was a case where even, there is a conviction, 5 courts upheld that and everything. There is only life imprisonment. There was no death penalty. So, and that's the matter of record. But according to me, much of the mercy had already been shown to them by not granting them that penalty. Case of this nature, 14 murders. Have we not seen in this country people being hanged for one murder? Are we not aware of Nirbhaya case and the conviction? For somebody to even argue that yes, it was a fit case for after 15 years and because of completion, I am not even going to even address that so-called ground, that sanskar and other things. I am not going to dignify that argument even, or that ground, even by addressing it. This is, for me, that shows that proves that the committee did not apply mind.
Why do you think
they
that
were ill-informed?
Why do you think they didn't apply them?
The moment any of the committee member, I'm just going by what you are saying. I do not know whether he is a committee member or not because I do not officially have the composition of the committee. I have not read the report order yet. But assume this is one of the ground for them, so to say, sanskar, improved and other things. But the moment you say sanskar is one of the ground, I'm sure they have not read the policy then. That means non-application on mind, not only on the facts of the case, the gruesomeness of the crime in this case, and talking to the jail authorities is something completely unknown to us when it comes to the legal system. We don't go by talking to someone. There has to be a report in writing. So if somebody refers to, yes, they were report of the jail authorities and they say their sanskars are good, we can actually then examine that also.
So finally, you have a strong ground for going in appeal against this remission. If non-application of mind, the gravity of the crime has been overlooked and clearly there is a heinous crime for which conviction has happened. Do you have a strong ground for going into appeal and will you do it?
So yes, she has a strong ground to challenge that order for judicial review, which is always, any executive order is always amenable to judicial review. But I have a point to make, that why each and every journalist is asking Bilkis alone, what is she planning to, whether she is taking any action against this order or not. she has done enough. She has a right which is guaranteed under Article 21 for a right to life with dignity, with peace, freedom, everything. That right has to be guaranteed by the state. Be it state government, be it central government. Let the governments, they are major stakeholders in the criminal justice system. The criminal cases are fought by the government, by the state versus accused, state versus A, state versus B. It's not Bilkis versus A. So this is a case fought by CBI as a prosecuting agency. The governments have put in their money, time, labor, manpower, whatnot to fight out this case up to the last court. It is for them to protect that order. It is for them to ensure that the justice is done, and their citizen, Bilkis is one of their citizens, that she is living in a state of peace, sense of security, and she is not feeling dejected that justice is denied to her. Let state ensure that, let one of the state body go, either state government recall its decision, reconstitute a committee, because apparently it appears the committee members were not applying their brains properly, or they were either ill-informed or not properly applying mind to the facts of the case. Or let the central government challenge it, let the CBI challenge it. Please go and ask, my request to you, please go and ask this question to the stakeholders, the major stakeholders. What are they planning? And I believe you, I am a firm believer in the system and the judicial system, our governments. I'm more than sure they must be planning to go and challenge it.
Well, absolutely. And that is why Bilkis also very specifically in her statement yesterday has said that the Gujarat government needs to undo this harm so that she is given her right to live without fear and in peace. As the citizen of our country, she deserves this. Thank you very much, ma'am, for having joined us.
Thank you.
But to even argue that the mitigating factor, let me open this up now, for granting this remission is somehow that they are Brahmins and they enjoy good sanskar. What does this even mean, Sri Raj Nair? Do their acts speak of good sanskar?
Well, well, I haven't heard this statement. If you're saying it, you have to ask the person who have given this kind of statement. We don't believe in any caste system. We believe in casteless Hindu society. Now, as far as this matter is concerned, now
even if we leave aside the caste, sir, let me actually spell out to you what is the context. Remission has been given. C.K. Rahul ji is the member of the remission panel. He was asked today by the Mojo Story, an online portal, what is the reason for giving this remission? He said, these men, we saw their conduct, they have good sanskar and they are Brahmins. Even if we leave aside the Brahmins for whatever God-forsaken reason he's brought this in, do their deeds speak of good sanskar because of which they should be granted remission?
See, I am in no position to say under what grounds they have been given, they have been freed. But at the same time, the fact remains, we have a very strong judicial system in this country. And I always say on your channel also, whether it is Kasab or whether it is Ajmal Kasab or whether it is Afzal Guru or the Khadins who raped young schoolgirls in Ajmer, they all have got a fair trial, and in case of Ajmer they were convicted and those rapists were roaming free. So we should not go in for a media trial. Now this particular committee has released them, and the concerned parties have a fair chance of going in for an appeal also. In this case, we don't want to go. We are not a party to go in for we don't want to be a party for a media trial.
So this is not a media trial.
Now the system
this is very clearly, as you just heard the lawyer for Bilkis Bano say, the case here is of the remission committee either not applying their mind or deliberately overlooking the gravity of the crime. Again, let's remember, these are not people who are accused. These are people who are convicts. And when I speak of gravity of crime, let me just quote to you. And this is, when you say media trial, they have undergone a court trial. And here is what the court said about these men. Court trial. Bombay High Court, by the way, upheld the conviction and said, Accused were searching for Muslims. As soon as they saw Muslims, they pounced upon them, assaulted them, and raped the women. From the clinching evidence placed before us, we are convinced that these people were in a mob on account of Godhra incident and was moving in search of victims. This is not a media trial. The Bombay High Court said this, that they pounced on their victims and they killed and raped them. 14 or 15 and a half years later, do they display sanskars that obliterates this judgment of the Bombay High Court, Mr. Nair?
Madam, for that only they have undergone more than 14 years rigorous imprisonment. And after that, they had the option of, and it was the Honorable Supreme Court which had said, which had sent the application back to the government of Gujarat. And after due process, they had all the right to be released. So now it's a process. We have to respect the judicial process.
Zeenat
and if
Shaukat Ali,
anybody, including all the parties, as we were listening to the Honorable...
Okay, hold on. Sriraj Nair says they have undergone rigorous imprisonment.
I beg your pardon?
Process has been followed. Then what is your problem? Zeenat Shaukat Ali.
Yeah.
Padmaja, it's so shocking and it's so shameful that this, this kind of an order, I feel, is very anti-woman. This is not Bilkis Bano, this is anti-woman. We fought so hard for Nirbhayas, the criminals and the murderers and the rapists to get the death sentence. And how many years I have personally invested and fought for this every minute of my life. And now we come to this woman who has been pregnant, she's raped, her small baby's head has been smashed, other people from our 7 other people from our family have been murdered. And what sanskars are we talking about? They were given a life imprisonment, and now on the 15th of August of all the days, they have been set free. What kind of justice are we looking at? Please note that I'm cutting across. This is nothing to do with religion or minorities or majorities. I'm not talking about the people who are sitting on judgment. I'm not talking about the people. I'm simply talking about those who are releasing such criminals.
Rishi Malhotra wants to respond to you. Rishi Malhotra.
Yeah, I actually just give me 5 minutes because I hope this is not an emotional debate, it's a legal debate. Because if the emotions were in place, then why this why? Of course, then let me complete in 5 minutes. Why so much of hue and cry now? Because it was a case where the High Court, on an appeal filed by the CBI, did not award death sentence, which order was upheld by Supreme Court. So at that juncture of time, there was no hue and cry that why in case like this, there was a death sentence awarded or not awarded by the Supreme Court or the High Court. But nevertheless, leave this apart. A man has been undergone more than 15 years of actual sentence. Supreme Court in May 2022 has reiterated a 20-year-old law which is consistent, which is that a policy which is existing at the time of conviction in the trial court, that has to be applied. In this case, the trial court convicted in the year 2008. At that time, the state of Gujarat policy of 1992 was applicable. That policy stipulated that a convict should undergo an actual sentence of 14 years before his case is considered for premature release. Now, I really fail to understand why so much of hue and cry, because the man has suffered a rigorous imprisonment of 15 years actual sentence. He has already suffered a conviction. He is not out in bail, or he has not been released prematurely in 5 years or 6 years. He has undergone the entire sentence.
Sir, like
so
Shobha
why
Gupta
no
just
hue
said,
and cry just
that
because a man has been released pursuant to direction by the Supreme Court?
Based on the gravity of crime. And here the gravity of crime is far greater than the punishment that these men have suffered. But since you brought up a legality, let Arjun Shauran respond to you. Why the hue and cry? Arjun Shauran.
If the gravity of crime... It's
not like they're released in 1 year, 2 years, 3 years. Arjun Shauran.
Just a minute.
Any remission policy is subject to what the government of the day decides. Any policy may allow you to be considered But the question is whether or not the committee or the government of the day has to release certain persons on a case-to-case basis. The policy my friend is talking about is a 92 policy that says you will have to be considered by a committee. Now the committee has to also apply its mind instead of saying they are Brahmins or for XYZ reasons. And they must understand 15 years is not life. Life as held by the Supreme Court in the case is for natural life. Entire life. These people are gang rapists, killers, murderers, and you say after 15 years, this is a gross arbitrary use of power. This decision must be withdrawn, and across the board, I think by the Gujarat.
Let me ask you a straight question, Arjun Sharan, for the lay people. Does the remission committee have to grant remission? You can also look at the case and say, no, we don't want to grant them remission.
It's discretionary relief.
This is gross. This crime is gross. We refuse your remission. The committee can do that, right?
They can do that. This is a discretionary relief. Your only right is to be considered after a certain number of years.
So then answer this, Mr. Malhotra, that essentially it boils down to the discretion of the committee. What possibly were the mitigating factors that this committee saw in the behavior of these men that somehow outdid what they had done in 2002? What have they done in the last 15 years which somehow makes it better what they did in 2002?
No, let me answer this. You please don't confuse an issue of behavior post conviction and prior to a conviction. What the committee foresees is that if a person is in jail for a good amount of years, what was his behavior inside the jail for a good amount of 14 to 15 years?
But sir, you also have to consider the gravity of the crime.
Incident. Of
you
course,
cannot say a man who has murdered a 3.5-year-old girl in the last 18 years has shown impeccable behavior, has been, trimming bushes every morning, and somehow he is a changed man. You remember that in the case of Nirbhaya, this same civil society was against the release of the minor rapist. Despite the fact that him being a minor was being called a mitigating factor, the same civil society said it doesn't matter. He should be tried as an adult because of the gravity of crime. Now we're talking about the same gravity of crime, where a child has been killed, her mother has been raped while she was pregnant, her grandmother has been murdered, her uncles and grandfather has been murdered. Gravity of crime strips any level of mitigation that these men may have enjoyed.
That's why I begin with this, that please don't mix emotional issues with legal issues. Even in Nirbhaya case, the most dreaded accused was juvenile. So what happened after 3 years? He was set free. So the law has to take its own course to a logical conclusion. So in this case also, a man has already undergone 15 years of actual sentence.
Okay.
There was no death sentence awarded by the Supreme Court or by the High Court.
There was no hue and cry. You're making an emotional argument.
Mr. Malhotra is seeing the law in only one sense. It's one-sided understanding of the law. That is not how things work. He is absolutely right that they had to be considered. But saying that without looking at their case, what they did, you just pass an order for purely political or whatever reasons is perverse. The Supreme Court has said that you have to look at all facts, all mitigating circumstances, all circumstances against the person also. You have to look at the judgment which was passed. You have to see what crime was committed. And I am saying the civil society is not against remission in appropriate cases, but you have to exercise your power in a responsible, legal, constitutional way, not this way that you can't life sentences actually
so
for life.
So how do you know that what has the committee decided? Nobody knows what has the committee decided.
We know for a fact they have let these 11 people off. We know for a fact they are being garlanded. They are being feted by their local authorities. So that is a decision which is being supported today by some of you. Unfortunately, that is a decision which is being backed.
And we know what the committee has decided because the committee member is speaking and he is saying, among other things, even if we leave aside that facile argument about sanskars, he is saying, well, there may be a possibility that somebody is framed in these communal cases. This person does not enjoy any past criminal record. We spoke to the jailer, he had no ill to speak of it. This is the consideration from the horse's mouth. Where are we in any doubt? And this reasoning, if it is being given by a member of the panel, what happens next? What should happen next? Zeenat Shaukat Ali. It's bad enough that this has happened, but the considerations being offered are even more problematic. What should be done next? What do you think as an activist and a woman?
I think this entire thing has to be reviewed by, the judicial. It has to be withdrawn. This is shameful for our democracy. It is unbecoming for women. And it has to be withdrawn completely. If it is a lifetime sentence and now after the empire there is a death sentence, I think we have to consider that sentence and not let them off. The gravity of the crime is extremely serious. And to let go and to allow, a judgment. It could be, the group that got together and made this remission, they may not have thought deeply enough. All their entire thinking was on the wrong tracks. Now, whatever that may be, from now, I think this entire thing has to be withdrawn, the case, and it has to be relooked into, and the punishment that is due to these people. There is no sanskar in murderers.
Yeah.
When they murdered and they raped and they ruined a woman's life, a pregnant woman, bashed a 3-year-old daughter.
And this is not an exception that is being sought for only one case. Think of the kind of precedent, and a very dangerous one, that this can set for any such future cases. This will be utilized perhaps by other states for their own convenience. And that will be a bottomless pit which we'll be racing towards. Let's hope better sense prevails. All eyes on you, the government of Gujarat. Thanks very much, all gentlemen. Zeenat Shaukat Ali for joining me.